A federal employee says she was sexually harassed by her supervisor, but her hostile work environment claim was dismissed. What kept her claim alive is what makes this story such an important lesson. And by the end of this video, you will understand why documentation, those notes, emails, and records that employees keep, can make or break a case. And you'll also see how the way HR handles an investigation can either protect or expose the company to serious liability. And stick around until the end, because I am going to share the key lessons you can apply in your own workplace so you know how to document your concerns in a way that could completely change the outcome of your experience. Hi, I'm Harlow Reed, employment lawyer, HR consultant, and creator of the HR Insider, and on this channel, I do more than share legal opinions. I break down real cases to show how the law might apply to your workplace, whether you're an employee trying to protect your rights or an employer trying to do things the right way. I talk a lot on this channel about the importance of documentation, and today I want to share a case that really demonstrates how powerful good documentation can be and how it plays out when it comes to an employment claim. I've had a few viewers comment that documentation doesn't matter because the other person will just deny everything anyway. And honestly, that's true. It's rare for someone to openly admit to wrongdoing. In fact, they'll often try to gaslight you into backing down. But here's the thing, a lot of people start to doubt their own experiences until they see it written down on paper in black and white and they can identify the patterns. When you start tracking what's happening, the dates, the conversations, the incidents, you gain clarity and confidence. You look at it and you know this is real. This is happening to me. And it matters. And when you have that clarity, you're able to move forward with confidence instead of second guessing every step because you're unsure if you're doing the right thing. And no matter the outcome of your claim, that kind of clarity, it matters. All right, let's get into it. The content shared on this channel is for informational purposes only and is not a substitute for professional legal advice. Always consult with a qualified attorney or HR professional for specific guidance tailored to your needs. And hey, don't forget to like and subscribe. We are going back to January 28, 2013. That's when the Army hired Nycoca Hairston as a general supply specialist at Pine Bluff Arsenal in Arkansas. She worked in the property book office under the Directorate of Logistics. Her direct supervisor was Dwayne Johnson, an equipment manager. Above him was her second-level supervisor, Deborah Moncrief, and her team leader was Elizabeth Blackwood. Like most federal hires, Hairston's first year was probationary. And not long after she started, Johnson allegedly told other coworkers that he thought Hairston was pretty and had a nice booty. Hairston didn't even know about these comments at first. She says coworkers told her later. Now, the Arsenal wasn't exactly a peaceful workplace. A lot of employees had personal and professional conflicts. And I have to admit, as I was going through this case, some of them were pretty outrageous. So Hairston, she found herself in the middle of some of them. By July 2013, things had gotten so bad that Moncrief actually called a meeting and told the group she was, quote, so sick and tired of you backstabbing bitches, and accused everyone of acting like big babies. Yes, those were the exact words she said, according to the court documents. But Hairston says it wasn't just general workplace drama. She had specific issues with Johnson. She pointed to two incidents in the summer of 2013. In the first, she said that Johnson told her and another coworker that they couldn't leave the office without giving him a hug. They went along, but she later said she really didn't want to do it. The second incident happened on August 16, 2013, during a work party at Moncrief's house. The party was during work hours and it involved drinking alcohol. Hairston claimed that Johnson dropped a salt shaker down the front of her shirt. When she asked him why, he smiled and said, "That's the best place for it." She believed he was drunk, and although no one else saw it, she told a coworker about it right after. And later in August, Hairston spoke with John Bynum, a coworker who also happened to be an Equal Employment Opportunity or EEO assistant. She told him about Johnson's behavior at the party. Bynum later remembered Johnson dropped a soda bottle, not a small salt shaker, but either way, she told him she didn't want to report it because she was still on probation and didn't want to get into trouble. Bynum encouraged her to report it anyway, and the next day he informed the Arsenal's EEO manager, Sharon Bolden, about it. Sharon Bolden had him prepare a memo and then brought the information to Moncrief, Hairston's supervisor. By September 4th, Johnson found out about the allegation. He denied it and accused Hairston of causing chaos at work. The very next day, September 5th, he started firing back with his own complaints. He sent Moncrief a memo accusing Hairston of rubbing against him, bragging that coworkers were jealous of her looks, refusing training, and creating drama in the office. Over the next few days, he sent multiple emails with more allegations, including that she rubbed another employee's leg under the table during a meeting and threatened to hit a coworker's car. On September 30th, Moncrief called Hairston into a meeting with George Well from the Army's Sexual Harassment Assault Prevention Program. Hairston admitted the salt shaker incident, that it had happened, but she declined to make a formal complaint. She said specifically, "I'm afraid of retaliation." And according to Hairston, Moncrief told her to apologize to Johnson, to blame the coworker who reported it, and to protect herself next time. By October, performance issues started piling up. Blackwood told Hairston she had missed weekly tasks. And on October 8th, Hairston received a verbal counseling from both Moncrief and Johnson. Hairston believed this was pretext and that she was being penalized for her earlier complaint that she made about what happened at the house party. Around the same time, Colonel David Musgrave, the Arsenal commander, did an outside investigation. On October 22nd, an investigator named David Barrington was assigned. After interviewing several employees, Barrington concluded on November 21st that Hairston's salt shaker claim was unfounded. Instead, he found that Hairston had pressed her chest against Johnson's back during the summer, essentially flipping the roles and naming Johnson as the victim and Hairston as the harasser. And on December 2nd, Hairston went to the EEO office to talk about retaliation and hostile work environment concerns. Just a week later, she overheard Johnson make a comment about the Victoria's Secret fashion show, joking with a coworker that his wife wouldn't let him watch because of the noises he made while watching the show. Hairston wasn't in the conversation, but she reported it anyway. And then on December 12, 2013, less than a year into her employment, Hairston was fired. The termination notice she received said she had created an offensive work environment, had been confrontational with coworkers, and even engaged in inappropriate touching. After her termination, things went quiet for a while. Hairston moved on, but the events at Pine Bluff Arsenal, they stayed with her, and over time, she decided to take legal action. She went through the administrative process, including EEO counseling and the required steps for federal employees before filing her lawsuit. And 5 years later, yes, 5 years, in 2018, Hairston filed a lawsuit against the Army, claiming violations of Title VII, alleging sexual harassment, hostile work environment, and retaliation. The Army argued against Hairston's claim by stating that her allegations, including the nice booty comment, the salt shaker incident, and the Victoria's Secret remark, weren't severe or pervasive enough to create a hostile work environment under Title VII. And the district court agreed, and they granted summary judgment for the Army. But here is where it gets interesting. Hairston appealed that decision, and the appellate court, they affirmed the lower court's decision about the harassment claim and the hostile work environment. But on the retaliation claim, things were a little different. The Army said they had legitimate non-retaliatory reasons for firing Hairston, pointing to performance problems, conflicts with coworkers, and allegations of inappropriate conduct. But the appellate court wasn't ready to shut that down. They said Hairston had raised enough red flags, like the timing of her termination and the way the investigation was handled, to create a real dispute that a jury needed to decide. When we talk about pretext, we mean the idea that the reason an employer gives for firing someone might not be the real reason. In Hairston's case, it was her documentation, the notes, and the records she kept about what was happening to her. It was that combined with the suspicious timing of her firing and how the investigation was handled. That's what convinced the appellate court there were enough red flags to send the case to trial. In other words, her documentation made the difference. It showed a pattern that a jury needed to look at, and that's why her retaliation claim got a second chance. But at trial in 2022, the jury sided with the Army. By then, Hairston was representing herself. She tried to challenge the verdict, filing motions for a new trial and to amend the judgment, but the court denied them. When she appealed again, the Eighth Circuit dismissed some of her arguments because of procedural mistakes. Basically, the paperwork wasn't filled out correctly, and it upheld the trial court's decision. So in the end, Hairston walked away with no relief. But this case is still a powerful reminder of how much documentation matters and the way an investigation is handled, how it can shape the entire direction of a case. If you're dealing with retaliation at work right now and you're trying to figure out the steps you need to take to protect yourself and to build a strong record of what's actually happening to you, my retaliation workbook can help you with that because it walks you through step by step how to organize your notes, track incidents, and keep the kind of documentation that can make a real difference in your case if it moves forward. And here's the thing, you can't assume something is retaliation just because someone was mean to you. There are specific steps you can take to help you better understand what's happening and to see whether it might be part of a retaliation pattern. There is so much that can be said about this case. On top of what I've already mentioned, though, there were mixed messages between the supervisors, the EEO office, and human resources. No one seemed to know how to handle complaints or how to escalate them, and that confusion only made tensions worse and fueled even more distrust and dysfunction at work. So this wasn't just about Hairston. This was a workplace that frankly sounded completely chaotic and out of control. You consider how determined Hairston was to keep fighting, even years later, and representing herself. It's easy to understand why she felt she was being retaliated against. Here's something important to note. Hairston accused her supervisor of harassment, and then her supervisor accused her of the same thing. A classic manipulation tactic is projection, and that's when someone doing the wrong thing accuses the other person of exactly that. There was clear evidence that inappropriate conduct was happening across the office, and the lack of clarity and consistency just added to the dysfunction. As a new employee, Hairston was likely trying to fit in without realizing it became part of an unhealthy dynamic around her. She hesitated to file a formal complaint because she didn't want to be seen as creating a problem. But the truth is, she was already caught up in a dysfunctional system. And if she was the only one held accountable for that dysfunction, that points to bias. It was her documentation. It's what got the court to recognize that something wasn't right. And in the end, even though the jury didn't find enough evidence to rule in her favor, the fact that her claim went to trial at all is still a small win because it shows just how powerful documentation can be. If you want to learn more about retaliation cases, be sure to check out the retaliation playlist here on the channel. Thanks for watching the HR Insider. I'm Harlow Reed, and I'll see you in the next video.